Anthony, you and I have been following this case intently for several months. You were also present yesterday, as was I, when we were listening to these closing arguments straight out of the gate. I want to know your prediction on how Judge McAfee is going to rule.
I think it's very unlikely he'll disqualify the Fulton County District Attorney's Office from the case, namely because the burden of production in terms of evidence rests with the defense here. And so there's one really important piece of unrebutted evidence, which is that Fonnie Willis and Nathan Wade's relationship ended before the indictments were handed down by the Fulton County grand jury and before charging decisions and charging recommendations were made to that Fulton County grand jury. And I think that's really the key point here in terms of the timing. And I think that the standard is wrong in terms of what the defendants are arguing. I think Georgia law is very clear. An actual concrete conflict of interest must exist in order to disqualify a district attorney's office from a case.
So, Anthony, let's stay on this, though, because there was a lot of questions, as you heard, peppered to the defense by the judge in this case as to the burden of proof. I heard Judge McAfee saying, hey, preponderance of the evidence is the standard. But to Steve Sadow, he said suggestions of wrongdoing certainly don't meet that burden. Do you agree with how Judge McAfee was asking the defense whether or not they understood what their burden was?
Yeah, it did seem as if there was a little confusion there. I think what's really at bottom at issue here is, you can't have a scenario where a defense attorney brings in, these allegations, salacious or otherwise, that are all hat and no cattle, and then muddy up the process just sufficiently enough to say, well, now there's an appearance of impropriety in the eye of a reasonable observer in the public. And so I think that's really a problematic dynamic that you would interject into the criminal justice system. Of course, we want prosecutors to discharge their duties faithfully and to not make, or to ensure rather, that defendants are not taken advantage of, or that the process is not abused in any sort of way. But I think prosecutors are partisans, right? Necessarily so. And so we have to really figure out what that balance is. We also have to make sure that when allegations are brought, they are substantiated. And really, in my view, at least, the defense has not produced the evidence to suggest that anything untoward happened to the extent that Fonnie Willis profited from this prosecution, that there's just really nothing there in that sense.
Anthony, we've been stuck on this idea of actual conflict of interest versus appearance of impropriety. The defense, I thought, trying to play cute a little bit yesterday, too clever by half, trying to tell Judge McAfee that it should be appearance of impropriety. However, you're the law professor. Educate our viewers. Is it actual conflict of interest or is it appearance of impropriety?
I think it's actual conflict. The appearance of impropriety standard is one that we use for judges, and judges are different than prosecutors. Judges are adjudicators. They are to be impartial and fair, and that's essential to the criminal justice system working well. But prosecutors are adversarial. They're not team defendant, and so different standards have to apply. The history of the statute for disqualification in Georgia goes back to 1860. And 1860, the statute that we still pretty much have today in some way, shape, or form, is talking about a common law standard for disqualification from an interest, right, a direct pecuniary interest, money lining the pockets of the prosecutor, or a relationship. For example, the prosecutor is close with a witness, used to represent a defendant, knows the victim, something of that nature that would call into question their ability to bring the case fairly. And that's a high standard to prove. It's an old standard. And so I think what the defense are trying to do here is import a new standard that is not consistent with Georgia case law, nor the common law origins and statutory history behind the disqualification statute that is still on the books today.
Always so smart and so informative. I'm out of time, Anthony, but I invite the viewers to go and look at the Atlanta Journal-Constitution. You wrote an exceptional piece tracking the history of that statute and really taking a deep dive in terms of what's going on in this disqualification. I appreciate you being here, Anthony Michael Christ. Thank you so much.
Thank you.
Meanwhile, we're going to go back to Florida, where a Trump-appointed federal judge, Aileen Cannon, heard arguments yesterday in Trump's classified documents case. Now, while there's technically still a May trial date, for now, Trump attorney Todd Blanche whined that it would be unfair to the former president to put him on trial before the November election, saying, quote, "We very much continue to believe that a trial that takes place before the election is a mistake and should not happen." Special counsel Jack Smith's team urging Judge Cannon to agree to at least a July trial start. But Cannon already expressing doubts. And while she has yet to make an official ruling, her infamously sympathetic ear to Donald Trump is leading some to believe that he just might get his way. Joining me now for more is Paul Butler, MSNBC legal analyst and professor of law at Georgetown Law School. You know, Paul, let's talk about what happened yesterday. There was zero ruling from the judge from the bench. There's still a May trial date, except all conventional wisdom suggests we're not going to trial in May. I want you to talk about, Paul, the fact that the Supreme Court just took up that 1/6 federal election interference case appeal on presidential immunity, and whether or not you thought that weighed on Judge Cannon at all in terms of her considerations of a new trial date.
So it didn't come up yesterday. Donald Trump thinks he should be immune from prosecution over classified documents, just like he should be immune for trying to overturn the election. The issue the Supreme Court is deciding in the D.C. case is whether a former president has immunity for acts he committed when he was president. In the classified documents case, Trump is making a different argument. He's charged for conduct after he left the White House. So he's saying that he should be not to be prosecuted. He could actually ask the Supreme Court to take up this issue as a separate case, which would cause even more delay.
Yeah, you know, Paul, something that stood out to me also was the fact that Judge Cannon brought up the 60-day rule herself, right? Judge Cannon asking whether or not the 60-day rule applied. Now, this is a judge. This is a impartial jurist who's supposed to be just calling balls and strikes down the middle. Why would Judge Cannon be asking the DOJ specifically about the 60-day rule?
That's a really good question, Katie. The 60-day rule isn't even part of the federal criminal code. It's a DOJ policy about when prosecutors are investigating a politician. They're not supposed to take overt acts like executing a search warrant shortly before an election. But this policy doesn't apply to ongoing prosecutions. So, for example, if Trump is already on trial in Florida or D.C., the judge would not stop the trial just because it's 60 days before the election.
Paul, let's also talk about the fact that Donald Trump keeps pushing the limits and the boundaries of getting information that should be protected, sealed, and otherwise not available. I'm not even talking about the classified top secret documents themselves in the discovery process. I'm talking about the motions he's filed to compel the turning over by the government of the names of witnesses and other people that participated in the investigatory process.
He wants to make the names of the witnesses public. Katie, there's no good reason for him to do that. And Jack Smith has legitimate concerns that those witnesses will be subject to threats and intimidation. And that's what's happened to witnesses, judges, and prosecutors in Trump's other cases. But, you know, I think the real takeaway from yesterday is just how Trump's defense team thinks that Judge Maureen Cannon is going to cooperate with their delay tactics. They claim that the trial needs to happen after the election. Otherwise, it's political persecution and election interference. But Katie, then they said they were cool with having the trial before the election as long as it's in August. They didn't mean that. The defense is playing this chess game to try to delay everything. If Judge Cannon sets her trial for August, that boxes out Judge Chutkan from setting her trial in September. And then as we get closer to the August trial date, Judge Cannon is likely to be sympathetic to more and more delay, pushing both federal trials after the election, which, as you know, Katie, could mean that they will never happen.